Hope you're all relaxed after the short little break and the beautiful ceremony. Now, ladies and gentlemen, we're going to go right into the public lecture here, and I'm going to ask Dave Hurley to come forward to introduce our speaker for this evening. Mm-hmm.
Thank you, Al. Klasi Gulpa, I welcome all of you. Welcome you to Wolastoqey territory, traditional Wolastoqey territory. This evening, I have the honor of introducing our speaker for the evening, and it's a special honor for me. I want to mention that before I give you some background information about. I think everybody knows Bob Ray, but I'll give you some more information. Bob Ray is a senior partner of Altius Clear Townsend LLP, where he works with First Nations across Canada as legal counsel, advisor, and negotiator. He served as Ontario's 21st Premier from 1990 to 1995, and the interim federal leader of the Liberal Party in 2011-2013. He was named Queen's Counsel in 1984, appointed to the Privy Council of Canada in 1998, named an officer of the Order of Canada in 2000, received the Order of Ontario in 2004, and Companion of the Order of Canada in 2015. In addition to his legal practice, Bob teaches at the University of Toronto as a distinguished senior fellow at the School of Public Policy and Governance. He has also written 5 books, most recently, What's Happened to Politics. He has a regular column in the Globe and Mail and also does ADR work with ADR Chambers. Ladies and gentlemen, Bob Ray.
Thank you very much, David, and it's a great pleasure to be back in New Brunswick, and a great pleasure to be back here at the university. We had a wonderful, for those of you who weren't here, we had a wonderful, and for those of you who were here, we had a wonderful ceremony this afternoon to open the conference. And that opening and the comments of some of the people who spoke, including the very David Purley, gives me an opportunity to start my discussion, because the premise of my talk this evening is that, and this is sometimes misunderstood, so I want to make sure I'm not treading on too many eggshells when I say this. When I say that there is a problem with the treaties. And the problem is one that has been discussed, and that is that the understanding of the treaties by the Crown and the Crown's representatives and the representatives of First Nations is quite different. So let's start from some premises, and I'm not here giving a law lecture, and I know there are many distinguished professors of history and law here, and I'm just, a workaday lawyer now, but also can't get rid of my political past as hard as I might try to do that. So there will always be a risk of oversimplification in what I have to say for the purposes of making an argument. And the rest of the conference can say, well, he was wrong about this and he was wrong about that, and that's fine. Believe me, nothing you can say would compare with what others have said about me over the last 40 years. Let's start from the word treaty. When the settlers came, when the Crown arrived, contrary to the mythology of the time and the mythology afterwards, they did not find a wilderness with no people. They did not find no one's land, which in Latin we call terra nullius. They did not find empty spaces. They might have put a flag down and said, we claim this for whatever crown or whatever monarch. But the reality, and we have to reinforce this reality all the time, is that prior to the arrival of European settlers, traders, fishermen, business people, whatever, there were vibrant communities right here. Here, in every part of Canada, every part of North America, in every part of the Americas. And the vibrancy of those cultures, those civilizations, those ways of life, has to be the foundation of our understanding of what happened. Because so much of our law, and indeed even our history, is based on the mythology of discovery and exploration. One of the, I think, very simple conclusions that, and very true conclusions that the Truth and Reconciliation Commission comes to is that we need to re-educate ourselves about who we are as a people, who we are as a country, and really work hard at listening and understanding that there are many different versions of this history. And so there are many different versions of the law. Whose law? It's important for us to realize that the people who lived here before European settlement had laws, customs, politics, the Confederacy. How do you get to a confederacy if you don't have a sophisticated form of political conversation which allows people to talk to one another about their relationships? And this is fundamental to the challenge we face. This is not written down except by the people who came and attempted to understand what was the world they were encountering. And so it's passed down by oral tradition, and it's passed down by custom. It's passed down by cultural understanding. And in some cases across the country, it's passed down by the actual memory of the people who were present at the time that conversations began about what kind of a relationship are we going to have. Now, we have three big periods of treaty making in the country. The first one took place here in the Atlantic provinces. The second were the so-called numbered treaties that were a feature of Canada after Confederation. And the third is what we call modern-day treaty making. And they're all very different, but they're also the same in this one fundamental regard. Even with the modern-day treaties, there's a disagreement. Even today, there's litigation about, well, what did we sign? What did we think we meant when we signed this document? What did we, each side, commit to do? And certainly when it comes to the treaties of peace and friendship, there was a misunderstanding. And David referred to it in his earlier remarks for those of you who missed his wonderful introduction to the history. And the misunderstanding is simply this. We know what the motivation of the Crown was in each case. But speaking of the peace and friendship treaties, we know from masses of documents, because the British wrote everything down. sometimes to their disadvantage, because now judges can go back and say, well, this is what they said they were doing, but this isn't actually what's in the document. It's clear that for the British, the treaties were an exercise in reinforcing the relationship between them, their crown, and the First Nations, so that they could essentially purchase the loyalty of First Nations who otherwise might go and express their relationship with another crown, the Crown of France. So essentially, they were imperial documents negotiated in order to gain the loyalty and the support of the First Nations who agreed to sign the documents. And I suspect, I don't know this for a fact, but I suspect that the written documents could actually not be read by most of the people who signed them on behalf of the First Nations, just by virtue of who they were. They developed a good oral understanding. They were able to converse with one another. They learned each other's language in that sense, but the written text, not so sure. From the British point of view, this was an expression of the Crown's sovereignty over the land. And basically saying, you give us this and we will provide you with protection. And by the way, if you take your stuff to the truck house, we will make sure that you get paid for it. But the British never saw it as anything more or less than a reaffirmation of their own power, authority, and sovereignty, and the acceptance by the First Nations of the sovereignty and jurisdiction of the Crown. Now, in the peace and friendship treaties, they essentially, in that sense, were attempting to forward a military and, to some extent, commercial alliance. But what is also clear from the oral culture is that for the First Nations, this was a different kind of understanding. It takes some historical imagination on our part to think about what would a culture that had not known about the arrival of strangers, what would they make of this arrival of these people? Different than other people who they had known for hundreds and thousands of years and with whom they had a relationship. And the only thing they could do was to repeat the ceremonies with which they were familiar, which would have been entirely interesting and fun for the British, but they wouldn't have really known what the significance of this was. So the wampum belt, the exchanges of gifts, smoking of the peace pipe, the tobacco ceremonies, all of the solemn ceremonies which reflect a nation-to-nation understanding, what we would say is a treaty, would have been ceremonially interesting to the British, but they would not have seen it as a relationship of equals. They didn't. The First Nations did. The First Nations saw this as a relationship of equals. And the difference in the fundamental interpretation of this relationship is so important in order to understand the sense of betrayal that then follows the administration of the relationship over the centuries since the 18th century. One of my colleagues in law has referred to this misunderstanding in this way, and I think there's a lot of truth in it. And that is that from the Crown's perspective, the treaties are really an expression that's similar to a divorce, And from the First Nations perspective, the treaties are about a marriage. In the First Nations interpretation, you're looking at how do we build a relationship, as David put it this evening. You're part of our family. We're all together here. We're equal, and we're relating to each other. We're welcome. We're going to share things. We're going to share the land. We're going to share our territory with you. We're going to share how we relate to one another. And so we're beginning a relationship that will last forever, as long as the sun shines and the rivers flow. For the British, not so much. We have your loyalty. You've accepted a relationship with us. Now, the peace and friendship treaties did not specifically contain the clauses which have now become so infamous, which is the ones that say, we give up our territory, we give up our title, we abandon, we yield to you, and you now have the land in exchange for which we get something else. I'll come back to that in a minute when I talk about the number of treaties. But the peace and friendship treaties still have to be understood in this way. So there is still this problem that we need to try and understand. And when we come to the modern day litigation, the Marshall case, for example, and other cases around the question of resource sharing, there's clearly a completely different interpretation between the two sides. And in fact, when you look at the Marshall case itself, I, ironically, was asked by Mr. Chrétien to be a mediator in the Burnt Church lobster dispute. And what was fascinating about that was not only a very different understanding of what the affirmation of the ability to fish and hunt in accordance with Aboriginal custom and not in accordance necessarily with some regulations that have been brought in by the Canadian government, you again have this basic misunderstanding about what is the nature of the sharing and what is the nature of the rights that are being affirmed. When we come to the numbered treaties, in the 19th century and the early 20th century, which were signed by the Government of Canada, in one case by the Government of Ontario as well, we have much more clearly the evolution of thinking in the minds of the Crown that it's really, really important for the Canadian government to be totally clear that it is taking control. It is taking charge. And it is making decisions from their perspective that clearly establish not a relationship of equals, but a relationship in which the state says, well, we'll take care of you in some fashion, but you have to give up all your title to any assertion of title to the land you have to abandon. And again, it's a complicated history, which I'm not going to summarize. Well, I am going to summarize in a few sentences, and it sometimes is not fair to all the different treaties. All the numbered treaties are a little bit different from each other, but fundamentally, it is clearly an assertion of power by the federal government. And from the Aboriginal perspective, again, you have this sense of, no, we didn't say we were giving up our land. We didn't say we were giving up our title, although that's what's in the document. But we certainly know from the evidence of Treaty 9, for example, which has been analyzed to a great extent, the far north of Ontario, people literally didn't know what they were signing and had no intention, from their perspective, of ever giving up title. And in the one case, the Sui case that is looked at by some of the cases that have been looked at by the court, they clearly indicate that, look, we have to look at the other evidence. We have to look at what else people have said in order to interpret the meaning of these documents. The law and policy of the country was based on the assumption that the Crown had control and that the First Nations were a subject people. Until the Calder case in the early 1970s, when the Supreme Court was faced with the facts from British Columbia, where there were no treaties, or there were some treaties, but there were no treaties in this territory, and where the Nisga'a territory, and where the court basically said in a very richly confused case, because there were so many different judgments and they were all competing with one another for who was going to be actually declaring. And in fact, it's not an affirmation of title, but what it is a case that stands for the proposition that the assertion by the Crown that simply by virtue of asserting its title, it therefore has title and no one else has title, the court said, not so fast. The legal premise that nobody was here and that nobody was occupying the land, that nobody was using the land, that nobody had prior occupation of the land before you got there, the notion you can throw all of that out and just say, hey, we're British Columbia, we have title. The court said, no, that's not right. So what happened as a result of that was that the Canadian government suddenly realized that they had a huge problem, at the very least a huge problem, in those parts of the country that did not have either a peace and friendship treaty or a number treaty. And so they started a process of what we call modern-day treaties. Modern-day treaties are varied. They range from quite extensive self-government agreements in Labrador to the James Bay Cree agreements, of which there are now 3, which have ceded quite a lot of jurisdiction, a lot of money, a lot of power of self-government, to the creation of the modern territory of Nunavut, to the agreements in Northwest Territories, to huge land claims and other agreements in Yukon, to the Nisga'a Treaty, a broad range. And they're not from an Aboriginal perspective, they're not uniformly wonderful. The abandonment of title has been painful, difficult, very controversial in some communities, and has given rise to enormous internal arguments about whether that needed to be done and why it had to be done. It's been the policy of the Government of Canada and of the provinces that they will only, the Crown will only reach final, if you like, treaties in the event that there is an abandonment of title, which I myself think is excessive and not necessary, and frankly not helpful to getting a much better understanding. But what all of this has done is to create now, in the modern world, today, 2015, different categories and classes of First Nations across the country. If the communities here were to do a study of what has happened in Labrador and what has happened in Quebec, for example, it would be an astonishing discovery to see how much more power, how much more authority, how much more money, and how much more resources have been transferred to the First Nations. Because of the historical accident that in Quebec there were no treaties in that territory. And as a result of that, those communities have now been able to take advantage of the modern sensibility of statecraft and reach a completely different agreement from what was arrived at in the treaties of peace and friendship, to say nothing of the numbered treaties. When you think about it for a moment, the numbered treaties is an example. You have to think it kind of bizarre to imagine that a people whose claim to the land was all of northern Ontario, which was the homeland of the Anishinaabe people and of the Cree people, and you would have to accept the theory that in exchange for $5 a year and 29 tiny little parcels of land in this vast space of land was somehow a fair exchange. You know, that's a reasonable deal. We'll give you all this land and all the wealth that's underneath it, all the territory, all the mining wealth, all the forestry. We'll give you all of that, and all we want is this little space, this little reserve, and $5 a year. That sounds like a good deal to me. It's preposterous. It's preposterous to think that that either was the bargain from their perspective, no, it just doesn't make any sense, or you have to go with the understanding that they had a very different interpretation of what it is they were doing. Just as to look at the Marshall cases 1 and 2, you have to believe that the First Nations had a very different understanding of what sharing meant under a peace and friendship treaty. And so, where are we today? Where are we today? Well, we're where we are partly as a result of a certain degree of irony. And that is that the former Prime Minister, Mr. Trudeau, who was profoundly skeptical about the notion of treaty rights and separate treatment for Aboriginal people, he expressed that many, many times, was finally forced by virtue of the court and the simple power of the facts to recognize that if he wanted to patriate the Constitution and he wanted to bring in a Charter of Rights, he had to recognize that there were treaties, that there were rights, and that they had meaning. And that's what happened when the Constitution was patriated. Section 35, which states very clearly that the existing Aboriginal rights and title are embedded in our new Constitution, was the basis upon which all of the litigation and all of the law that has emerged from the Supreme Court of Canada stemmed from that one decision by Parliament to add Section 35 to the patriation package. It was not part of the original package. It was not part of the original desire on the part of the federal government. It happened because of a long process of argument and lobbying and fighting hard that was led by the Aboriginal leadership of the country at the time. But you know, whenever I get into a discussion with some law students, which I do from time to time, and they all say, well, look at this case and look how far the court has gone, look at the court, look at what the court has done. I say, you're right, the court has done a lot. But why do we have all these court cases? Why do we have court cases? And they say, well, what do you mean? I said, it takes two to argue to get to court. So who has been resisting all the way through? They say, well, the Supreme Court, I mean, Bill Gallagher, who's a guy who's a sort of a constitutional lawyer a bit, says, you know, the court it's 220 wins for the First Nations in the Supreme Court of Canada. You say, great. Well, what does that tell you? Who's on the losing side? Who's resisting every step of the way? Who's forcing every single case to go to court? And not just go to court, to go to the Supreme Court of Canada. Who's doing that? the governments, the federal and provincial governments. And the thrust of what I want to say today is, look, it isn't right to force First Nations in every single instance to go to court, to take the case, to spend the money. I mean, I represent a law firm. What kind of a law firm is going to say, don't spend your money on a court case? So I'm arguing against interest, as they say, and my partner, Renee Pelche, will be speaking to me after this discussion. But my point is this. The court cases tell us one thing more than anything else. And in every case, in fact, Mr. Justice Laforêt said, and he's a distinguished New Brunswicker, said in the case of Delmagook, which is one of the most significant title cases in the modern history of the court. He said, when you want to resolve issues of title and you want to resolve issues of sharing of resources and everything else, please negotiate these things. Don't come to us to make the settlement. You settle these things, negotiate them, work them through, and make sure they happen. I couldn't agree more. But the problem has always been, and the problem remains, that up until now, the federal government and the provinces have said, we don't see a big problem with the existing treaties. We're interested in talking about other treaties. But I think the policy has to change at the federal level and at the provincial level. And people have to recognize that the implementation of treaties that are 200 years old requires negotiation. And in order to have a negotiation, and this has been reaffirmed by the Truth and Reconciliation Commission, there has to be a political will on the part of most Canadians. Most Canadians are non-Aboriginal. The majority of New Brunswickers are non-Aboriginal. Majority of Nova Scotians everywhere across the country. The only exception is Nunavut and the Northwest Territories, where there's a substantial plurality of Aboriginal people. It requires a return to fundamentals about what is this relationship. Is it based on recognition and respect, or is it based on subjugation? And you can say, look, the majority, you can say to them, you've tried subjugation. You've tried the Indian Act. You've tried the residential schools. You've tried active discrimination. You've tried marginalization. You've tried ignoring people. You've tried treating people as if they're second-class, third-class citizens. You've insisted that people assimilate, that they forget their language, they forget their culture, they forget their spiritual practices. You've tried all that. How's that working for you? How's it working for Canada? The answer is it's not working at all. It's created poverty. It's created disempowerment. It's created a sense of marginalization and a sense that people are not as good as other people. And I personally can think of nothing sadder to know that there are people who feel that they are not fully people because of the history of discrimination and subjugation that's been described now in our history books. And that's why I agree with Murray Sinclair, who says, the truth will set you free, but first it will really piss you off. And that's what's happening. People are getting pissed off because there are no secrets anymore. And when the time comes for the Commission on Murdered and Missing Indigenous Women, even more stuff is going to come out. And people are going to look at themselves and say, how could this have happened? How could we have reached this point of exploitation and discrimination? So the process of reconciliation has to start. It starts with knowledge. It starts with understanding. It requires a knowledge of history, but not just of history, of what people are experiencing today. How do people feel today? And then it starts with a process of saying, how can we create a government-to-government relationship that is respectful, that is practical, and that is going to put people on an even footing. All nations require land, all governments require land, and they require money, they require revenue. If you don't have land and revenue, you don't have the capacity to be a real government. And it just seems to me the logical step to say to the governments of New Brunswick in Canada, Ontario in Canada, everywhere across the country, Saskatchewan, Manitoba, everywhere else, you say, look, if we're going to get to a respectful relationship that truly recognizes the fact that Canada's original people need their own governments, need their own capacity to govern themselves, and need the revenue to be able to do that, and need the jurisdiction to be able to exercise a degree of authority. We can't just rely on a court to set up a government. We can't just rely on litigation to solve the problem. It's going to require negotiation. And not a negotiation that needs to take forever and ever and ever and ever and ever. A negotiation that says, we want this to happen. I was talking with a reporter today, and he said, well, what's in it for everybody else? What's in it for the majority? And I said, well, it's easy. Self-respect, the more likelihood that people will actually participate in making decisions and will take ownership of those decisions, the greater likelihood that, yes, it doesn't mean that there will be no resource development. It means that resource development will happen that is actually going to flow some benefits to people who've never had any benefits from resource development. And in the absence of that, we will continue with conflict, with increasing confrontation, and frankly, with increasing poverty. And none of these things is in the interests of the majority. None of these things make sense for non-Aboriginal Canadians and their governments. All of which is to say that this is not easy. I'm not pretending for a moment that it's easy, or pretending for a moment that there won't be times of conflict and profound difference of opinion. But I do think we have to understand some things, that the courts, as important as they have been in helping to assert the value of self-government and the nature of the inherent rights of the Aboriginal people, the courts do not bear the responsibility alone for getting us to a better place. I think there's been a tendency sometimes for governments to say, well, I'm only going to do what the court tells me to do. That's what I'm going to do. I'm going to wait for the court to tell me what is the least I have to do, and then that's what I'm going to do. And that becomes the political path of least resistance. But the problem with that is that the issues don't really go away, and the issues are never really settled on that basis. One of the ironies of my time in New Brunswick when I was here as the Burnt Church mediator was that those of you who are lawyers will know that there were two Marshall decisions. There was Marshall 1, and then there was Marshall 2. And as a result of Marshall 1, which you'll recall, Donald Marshall was charged and convicted of fishing and harvesting illegally when he took 430 pounds of eels out of the water and said that it was for his traditional rights under the treaties of peace and friendship, that he was simply gathering and dealing with his needs, and that was what was allowed for. The original decision of the court said, yes, we agree that you are allowed to do that, and we agree that your conviction should be overturned. As a result of which, there was some considerable degree of activity on the water near Burnt Church, where a number of people went out on the water and said, well, we can now, thanks to the Marshall decision, we can now gather lobsters whenever we want for our own use. And the people who had fishing licenses said, no, I don't think so. And they went out on the water, and there was quite a lot of conflict and threats of violence and a lot of anger and a lot of real conflict. And I was asked by Mr. Chrétien, as well as the Aboriginal leadership, to try to see if there was a basis for mediation. And what was ironic about my time there was that the government was waving Marshall II in my face, because Marshall II said, well, Marshall II is very interesting, because it wasn't actually a decision or a clarification, as Mr. Justice Binney is always very clear to point out to me whenever I tell him that, I had an interesting mediation. There were two of your decisions were being waved about by both sides. I said, so I had to decide which one of your decisions was helpful in this regard. It was, anyway, what Marshall II stands for, the proposition, is to say, yes, there's a traditional right, but that traditional right doesn't mean that the government can't regulate how that traditional right is exercised, and there's a right in the governments to provide for conservation and to provide for regulation. And ultimately, the dispute was resolved by the parties agreeing to a process of discussion about how licenses would be allocated and additional licenses would be granted and people would be allowed to participate fully in the fishery, and so things have changed and things have evolved, which is what you hope for in a negotiation. But that experience convinced me of one thing more than anything, and that is that as important as the court cases are, the courts themselves can't get us to the final stage of where we need to get to. And I'm aware that there are a number of law students in the audience, and I just say it's important to understand the law and with the understanding behind it, but it's really, really even more important to understand that you serve the interests of your clients best by telling them that, yes, you can go to court, and if we need to, ultimately we will, and we should never be afraid to use the leverage of going to court if we think we can win. But don't forget that ultimately, as Mr. Justice Lemaire has said in the Delmagook case, we're all here to stay. And ultimately, the question is a political one, which is, what is the nature of the coexistence that we are going to establish in this country and in each of our provinces? And how do we do that, and how do we achieve that in a way that is respectful of the interests of everyone? Not easy, hard to do. Pain and suffering, compromise, understanding what's required. But what I think is so healthy and important about this conference is that we're going back to the origin of this relationship. And we're trying to understand what were the parties thinking when they signed this? And how was it interpreted and seen by the people who were there? And why is it being celebrated today as a day that forces the majority to understand that, yes, there were treaties? And so let me close where I began. A treaty is not a municipal bylaw. A treaty is not a corporate commercial contract. A treaty is not a piece of legislation that belongs to only one government. A treaty, by its very nature, is about a relationship between nations, governments, peoples. we are all, in this country, treaty people. We are treaty people for one simple reason. Before the settlers arrived, there were people here. And those who came at some fundamental level understood that a relationship had to be established that was one of respect. For all the disagreements about how do we interpret these documents, what do they really mean, what's the modern day significance of this clause or that phrase, all of that is less important than this fundamental premise that when we came, people signed treaties in an effort to achieve understanding. I don't see how we have any other choice to keep faith with that premise and understand the logic that applied then still applies today. And that's why the renewal of treaties and the broadening of treaties is so much more the path we need to follow than the attempt to fight the treaties or to abandon the treaties or to pretend that that fundamental relationship, a relationship that needs to be reaffirmed, is not there. Thank you all very much. It's been great to be with you and to be part of your ceremonies tonight. I really appreciate it. Thank you so much. Thank you. Well, now we come to question period. Anybody has any questions? Sure, everybody's happy, but yes, ma'am.
Big fan of Justin Trudeau. I get the red nails and everything.
Good.
I just hope that, what is your interpretation of nation to nation? Because you hear that all the time, and even talking to Justin when he was here in Woodstock, it wasn't really clear to me what his intent was with those words. Is it just lip service, or like what do you think his interpretation?
Well, I mean, first of all, I can't, as I'm sure he would want to make clear as well, I can't speak for him. But what I can say is I think the modern day meaning of it is that we recognize that First Nations have governments, and those governments have rights and have power and jurisdiction that has to be recognized and formalized. And I think that more and more it's going to be a matter of, well, what kind of governance can we establish that's going to put that relationship on a renewed footing, on a better footing than it's been so far. There are 670 odd bands under the Indian Act. They're now referred to as First Nations. But to be realistic, a community of 40 or 50 people where another 100 or 200 people are living off reserve it's important for within the Aboriginal communities themselves to begin to establish governance that goes beyond just the simple band under the Indian Act and say, well, what is the nation for the purposes of this discussion? That's what it means to me.
Like, for instance, like maybe talks with the Assembly of First Nations, if they like to kind of collectively represent all of our First Nations across the country.
On some issues there will be, and other issues there will be other tables established. I know that in New Brunswick, because I've been following the situation, there's a need to look at how many tables there need to be to really reflect the diversity of the Aboriginal communities. There's a difference between Mi'kmaq and Maliseet, and that has to be respected. if that's what people want. If people want two tables, that's fine. My own view is that's something government should be respectful of. What is it that the First Nations want? I'm involved in a non-treaty negotiation in the north of Ontario where there are 9 First Nations. And I've learned, somebody said to me, "Oh, you've left politics." I said, "No, not exactly. It's just a different kind of politics that I have to learn how to deal with." Sir?
Do you think that you can have effective negotiations without an accepted external arbiter, so that both sides are going to pretend to be happy?
I think it will depend. I think having an outside mediator sometimes helps. I certainly think that, for example, in Labrador, one of the features of the self-government negotiations has been an agreement that where the parties can't agree, there will be a binding arbitration. So that you say, we're actually going to leave up to an arbitrator to decide, how this particular situation is going to be resolved. If we can't agree between ourselves, we agree that somebody else should do it. That deals with the concern on the part of the governments that free, prior, and informed consent will lead to very tiny communities having an absolute veto over everything on the one side, and it's the reason the First Nations are prepared to do it is because they realize that they're actually they don't have a lot of leverage in terms of their population size. So they need somebody to say, okay, you're not the government and you're not us, but we want fairness from you, and we're prepared to accept your decision. I think it's a good compromise. I think it's a good way to do it.
The issue is how do you enforce that? Doesn't that third party go indirectly to the government to get the power to enforce?
There will be different kinds of enforcement, and I think it will also partly depend on the extent of the Aboriginal capacity for self-government in terms of who will enforce what. But one of the premises of self-government as it relates to provinces and even in some cases of municipalities is that they in fact have the jurisdiction to deal with a particular problem, and that jurisdiction has to be respected by others. I don't think it's impossible for us to imagine a situation where the First Nations themselves will have responsibility for policing certain agreements and for, in fact, enforcing them. Silence all around. People must be hungry or something. Okay, yes, ma'am.
The Truth and Reconciliation, do you feel that now that kind of wraps up, will that have any impact on going forward with what you're proposing?
Yes, I think it will, but I think the key thing is to remember that we've actually, can't do it all in one night, but I mean, we've actually been through a process. I mean, one of the greatest, in my opinion, royal commissions in the history of the country, there have been a lot, was the Royal Commission on Aboriginal People, RCAP as it's called in the business, which came out in the early 90s. Very comprehensive document, very comprehensive call to looking again at our history, very comprehensive on the need for self-government, lots of recommendations. It was taken by the government of Canada and just put on a shelf and completely ignored. So the key challenge for Truth and Reconciliation is the report going to be ignored? And there's some very specific things in there about the need for Canadian law and international law to be reconciled and brought into line with each other, about the importance of looking at free, prior, and informed consent as the basis for Canadian law, both in the provinces and at the federal level, as well as changes in education so that everybody understands what the impact of the residential schools experiment was. I mean, let's not forget, this was not a 10-year exercise. This was a process that went on for over a century. Over a century. The most disastrous social policy one can imagine in terms of its impacts, in terms of its utter and complete failure. And its impact is not going to be, is still being felt today. And sometimes people really don't understand, non-Aboriginal people don't understand that treating people the way we treated people and taking children away from their parents as a matter of public policy, breaking up families as a matter of public policy, telling people they had to abandon their religion, abandon who they were, and abandon their identity, and give up their Indianness. This was not a policy that lasted 10 years. This is a policy that lasted for 125 years. And, you know, you can do an apology in the House of Commons saying, gee, we're sorry about that. Well, you know, that's 125 years of a truly disastrous exercise in social experimentation, which was a disaster. I don't think an apology cuts it. I think you've got to say, what is the program we're going to put in place to understand how much damage we've caused and how, frankly, some of the damage cannot really be easily undone in terms of its social impacts on families and social impacts on people. How do you undo that? And it's something we have to look at ourselves in the mirror and say, this is what we've done as Canadians. Now what are you going to do? You know, it's a challenge. So the Truth and Reconciliation Commission, whose final report will be out, I hope, this year. We've had two sort of preliminary reports, and now we're hoping that the final report, which is going to be, I mean, extraordinarily painful and difficult reading for Canadians to understand the full degree and extent of the racism that was absolutely embedded in every step that was taken on Aboriginal policy. Yeah, at the back, sir.
You spoke about 670 bands, small bands throughout Canada.
Indian Act bands, yeah.
So paint me this picture. Here in the Western territory, we have 6 Palisade chiefs. We have 1 in Quebec, and we have 1 in Oakland, Maine. So we have 8 Palisade chiefs within our territory. If we have 8 Palisade chiefs walking in unity to come back together as a nation, paint me the picture of what that partnership will look like in the future.
Well, I think the partnership, and I don't think you can exclude it from the partnership of others, but I think to me what it represents is a possibility to go to the governments in question, Quebec, New Brunswick, and Canada, and even the United States, though that's an interesting question as to how that happens, and say, how can we create greater degree of self-government? How can we create coherence in how we deliver health care, how we deliver programs? How can we establish a revenue base that makes sense for us? How can we gain greater possibilities of sharing our language with our people? And I think the point that you raise is, for me, the critical point, and that is, how much unity is there? And I always give the example of, everybody understands this one because we were all kids once. You want to break a stick, you can break a stick. Put 8, 9 sticks together, you can't put it over your knee, you can't break it. And that has to be the level of unity that's created. What the Indian Act did, and still does, and it still was intended to do, and it still has this effect, what it was intended to do was to divide people against themselves and to deny the capacity of nations, Maliseet, Mi'kmaq, across the country, to act as nations, to act as people who could say, here we have some common interests, this is what we want to do. If under the Indian Act, you're all just Indians, everybody's just Indians, and you just say, we'll divide up these communities and we'll dole out the money. I mean, it's not functional. It's not a modern way we can proceed. If we were looking at any other country in the world and saying, how are you doing this? And they'd say, this is what we do. You'd say, well, that's crazy. You can't sustain that into the future because it doesn't meet the simplest tests of either human rights or efficacy. So there's a lot of steps to be taken, but it can be done. I'm quite convinced it can be done. Yeah.
You've talked about free, prior, and informed consent a couple of times. I'm wondering if you have any perspectives to offer
Well, to me, this is sort of the next logical step. And it's a logical step because, in effect, most companies, we have this situation now where Canadian mining companies, when they go overseas, know that FPIC is the standard. If you want to develop this mine in this area, you need the consent of the people in whose traditional territory you're operating. And I talk to a great many business leaders, and they say, we have no trouble with consent. If we can't get consent, we have no business doing this. And it's not just because they're really nice people, many of them are, but it's because there's a practicality to that. And that is, if I have resistance every step of the way, how can one possibly, build a productive relationship going forward? I think, first of all, courts can evolve in terms of their decision making. All of the doctrines that have emerged, honor of the crown, the duty to consult, the duty to accommodate, are a product of certain interpretations in history. There's no, and even in the latest Chilcotin case, Madam Justice McLaughlin, I think it's paragraph, I'm not sure what it is, maybe 109, I could be wrong, said very clearly, if you want to develop, then you always can get consent. That's certainly there as something that's a logical extension of where we're at. I personally think that FPIC should become the law of the land. I have no problem saying that. I think it's a logical extension of where we are, and I don't think it's fundamentally a change. I think the one thing that it clarifies is the problem with this notion of simply you have a duty to consult is that you can say, well, I've consulted. How long have you consulted for? What's a reasonable period of time? And what do you have to put on the table in order to arrive at an accommodation? And the courts will say, well, we can't dictate that bargain. It's not up to us. You sort of say, I kind of think it's a bit of an illogical conclusion, therefore, is a company can just go through the motions of talking and yakking and saying, do this, da, 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 blah, and then say, well, we consulted and we did our best. So now we're going to go ahead anyway. To me, that just creates a situation which is bound to create more conflict rather than less conflict. The principle of free, prior, informed consent is very clear. Those tests are clear. Were you autonomous in making this decision? Was it before the decision was made? And were you informed about the advantages and disadvantages of proceeding with whatever proposal was in front of you? Those are things that you can tick the boxes and say yes or no. And to me, it's a preferable standard to the one that we're now facing. Yeah.
Are there lessons from other countries that we use on a go-forward basis that would help us?
Well, every country is wrestling with this question. The models vary. And if you say to me, is there one country that you could say that's our model? I don't think there is. I think that you will find, for example, that there's some leapfrogging going on. And I would say the best thing we can learn from is not just what goes on internationally, but also what goes on in our own country. There's tremendous variation between and among provinces and territories as to what's the way to go, what's the best way to go. And I would argue that some of the most advanced situations that we've seen are in our own country, where it's not a huge leap to say, well, if you can do it in Quebec, why can't you do it in New Brunswick, or if you can do it if the James Bay Cree can have this kind of a degree of self-government and devolution and greater degrees of autonomy and increased revenues, why can't that be the case for the James Bay Cree just on the other side of the Ontario-Quebec border, where it's the same people? It's just that your decisions, one government decided to sign a treaty in 1905 and another one decided not to sign a treaty, but to have to sign a treaty in the 1980s and 1990s. I mean, that's a totally illogical situation, which in fact is what people are experiencing. Same nation, same language, same people. Different jurisdiction, therefore different treatment. It can't be sustained. Yes, ma'am.
We talk about governments and First Nations in Canada, and we hear of all these conflicts that are going on, the fracking and all of these other things. Is, in the US, it's different. We don't hear a lot of all that turmoil. Does it go on there? Are they not bound by the Indian Act? And what makes the difference?
The American legal framework is different from ours. And I would also argue that if you look at the American situation on something like fracking in the eastern United States, New York State has decided not to do it. Pennsylvania has decided to do it. Different jurisdictions have taken different positions, and different First Nations have taken different positions. There are lots of examples of First Nations that have decided that resource development is an invaluable part of their rebuilding, and that they see that as an advantage to them from a financial perspective and from an employment perspective, and therefore they're quite prepared to agree to it, provided they are given an opportunity to participate in the benefits. Other places, it's seen as not being acceptable. The same is true in Europe. The French government has said no, but other governments have said yes. So I think it's just a matter of the decisions and choices that are made in each jurisdiction. The key point is that obviously there has to be a way to engage the First Nations in either giving their consent or not giving their consent, and how that is done also requires good governance all around. You can't have, two people deciding on behalf of an entire community that something will or will not happen. And I think one of the side effects of free, prior, and informed consent is that the courts and everybody will say, well, how do we know that's the decision of the community? How do we know that's the First Nation itself deciding? Or how do we know that it's not just a few people in a room saying we don't want that to happen, or we do want it to happen? So it's going to require greater transparency and accountability in how decisions are made. And I personally think that's a good thing. Okay, last question. Yeah.
You just talked about transparency in governance, and you talked a lot about negotiations. And I just wonder how we move forward in these negotiations that you speak of, with the concerns about the framework in which Aboriginal governance has to operate under, which are kind of alluding to the European style of governance, which they're kind of forced into doing, versus traditional governance. And for example, like the Assembly of First Nations it's not elected by the people. So how do who speaks for those that feel disenfranchised under that current system? And the challenges that are presented from the uniqueness of each community when it comes to these negotiations?
Those are all good questions. I mean, I think the whole question of Aboriginal governance is evolving. It's evolving very rapidly and very quickly. I mean, I'm involved in some situations in British Columbia, for example, where there are traditional forms of governance which one has to accommodate and deal with and understand in order to relate and connect it to the bands that are duly constituted under the Indian Act and that are elected. Having said all that, I would have to maybe challenge you a little bit and say that I think it's up to the Aboriginal communities themselves. The AFN is not an organization that was formed by the Government of Canada. I mean, these institutions are the product of the evolution of governance and politics within the Aboriginal communities themselves. And if people are not satisfied with the forms that they have, then they'll have to figure out, well, what are the other forms? On the one side. On the other side, I do think that it's pretty hard to get around what I would call an increasingly universal standard of equality between women and men, democracy, and the rights of people to participate and have their say and have their votes recorded. I think it would be very hard to justify decisions that were made on the basis of some other formations that didn't meet those basic tests. I think it would be very hard for a government to say, well, we think that's a European, quote, way of doing things. I don't think that's the case. I think that if you look at international law, increasingly, there are expectations with respect to what good governance means, whether it's in Africa or anywhere else. And so you have to respect this notion that there will have to be some elements of democratic accountability in what is done. On the other side, and this is one of the arguments I've always made in the House of Commons, is that, well, where's the accountability on the government side? They pass accountability acts and say you've got to do this and you have to have this, and now you say, well, okay, what about you? How do we know what revenues you're going to produce from year to year? How do we know how you're going to treat us when it comes to accountability? Where's your accountability to us for what you do and what you haven't done? And that, I think, is something that we have to sort of put on the table in the discussion. I think we'll stop there. Thank you all very much. I appreciate it. Thank you.
Well, first of all, I want to thank you for your presentation. We appreciate your presentation and your willingness to answer questions as well. We want to offer you this gift. This will remind you of Lusway territory.
Okay.
Okay, so it'll be in your office.
Thank you very much.
Look at it.
It will be. Thank you.
Okay, thank you very much.
Thank you very much. Thank you. Thank you very much. Thank you.
Willie Wynn, thank you very much, Mr. Ray, for that lecture this evening. And we are going to end our conversation with the closing ceremonies. But before we do so, I just want to remind you that we will continue the conversation here at the Wu Center, starting at 9 a.m. tomorrow morning. We certainly invite you all to join us here to continue discussion on Peace and Friendship Treaty Days here at the University of New Brunswick. So at this time, I'm just going to turn it over to the elder in residence here at the University of New Brunswick, Elder Imelda Perlin.
You want to hold the wampum belt up? So what we're going to do is we're going to hold the wampum belt up because this is it just got delivered to us 2 days ago, so it's very new, and I think it's a good symbol of the relationship we're trying to build by offering this this gathering, and hopefully we'll add another row. And I think what wasn't mentioned before was that this is made by a beautiful young Mi'kmaq woman. And the belts were actually constructed by women, and you could, and the symbolism is the 13 rows, which symbolize the 13 moons, which actually tell us about the woman's role in the political system. So even though we weren't allowed to be leaders, we were leaders in our own way as clan mothers, and so that's what's symbolized there. So I just want us to, if we could stand together, please. And if you could just look, I wish we could do a circle. That would be the best way to close the ceremony. And, but if you just keep the belt in mind and its promise, and so that we will always make sure that there's a spiritual component to our negotiations from here on in. I just gave gratitude to our speaker for bringing what we call good news. When visitors come to a territory, usually they bring good news, and we always want to make sure we give them good news to take back to their territory. So we have to give gratitude to be the Haswagan for all our thinking, whatever room you took in what was said tonight.
and what you witnessed here tonight. The medicines that were smelled here tonight as a reminder that we're all walking on this earth together. And of course, the kind words, the praise, and the encouragement that we shared, and the songs that were sung. And of course, what we carry in our heart to always make sure that there's enough room for this vision, for those 7 generations yet to be born, so that we will be the examples of what our ancestors are seeing today, us as examples of why they signed those treaties. Wuliwan, safe journey, Apachich.